Bring in my guest now. We have criminal defense attorney Lara Yeretsian joining me for this hour. Lara, so glad to have you along. I want to talk about, well, there's a lot to talk about with this case, right? A lot of key motions brought up from both the state and the defense in this pre-trial hearing. Let's start with what Julia was talking about. There is an alleged confession of the defendant himself saying what he did, that he broke into Tara Grinstead's apartment, that he hit her when she discovered him trying to steal from her, and that he had to do what he did. What do you make of the defense strategy of trying to counter it with this Jackson Dino hearing? And then also they want to call experts, Lara, to talk about false confessions in the trial.
I think it's the right move by the defense. I mean, the one thing that they don't want to come into the trial as evidence against their client is a confession. Any jury that hears a confession is going to take that seriously as evidence against the client. So what they're doing is not only are they're trying to get this kicked out. So if it's kicked out, wonderful. If it's not, I guess that they're also trying to bring in an expert to show to the court at least that this was coerced. It all depends on what the detectives were doing on that day and what state of mind Ryan Duke was in. I mean, he may have been under the influence of drugs. The officers may have kept him in a room for many, many, many hours. They may have used force. They may not have allowed him to rest at all. So there's all sorts of factors that can come in, and the court can look at all of them and decide if this was coerced or voluntary. And if this can get kicked out, then he's got a shot at this trial.
Yeah, you're right. There's still a lot of evidence for the prosecution, especially if the judge is able to do what Julia said, take judicial notice of this science for the new DNA testing on that latex glove found at the crime scene, tying it to Ryan Duke. But also there's a lot of, we call them hearsay witnesses, but the fact that Bo Dukes told people who was responsible. He confessed to his part in trying to conceal the body, but also that Ryan was the one who actually murdered Tara Grinstead. In fact, at Bo Duke's first trial, his girlfriend testified against him, saying that he was responsible and also pointed the finger at Ryan. Let's take a listen.
And that he had put her body on, or he had taken his truck and put her body on the Hudson property in Fitzgerald, and that he helped to destroy the body.
And that was Brooke Sheridan, of course, the girlfriend of Bo Dukes at the time. How damaging is that type of testimony to come in this trial, Lara?
Obviously, it is damaging, unless the defense knows something that we don't know, and it's possible that Bo Dukes had a reason to cover it for someone else, and he was lying then, and he still is lying throughout because he's covering for someone else.
Right. And still with me, criminal defense attorney Lara Yeretsian. Lara, I want to get your take on this case. The prosecution calling a lot of witnesses, those who worked at the hospital, those who supervised Dr. Husel. And what do you make so far, especially of Dr. Ralston there, really trying to set up the frame that what the proper procedure or protocol was for caring of those type of patients in the ICU, really to kind of set the stage that Dr. Husel didn't do what was proper?
Right. I mean, that was the purpose of that witness, right, to set that up. But the issue is that there have been other witnesses after him, and one of them was a pharmacist. And one of the things that he told the officers who had interviewed him was that you're going to have a tough time proving this case because there's no maximum dose of fentanyl for patients who are being taken off of the ventilator. And also my understanding is that evidence came in about how one of the patients who had passed away had been given 14,000 mcg of fentanyl the day before during an operation. And there was also evidence of Dr. Husel having helped resuscitate, given CPR to one of the patients and basically bringing that patient back to life. So there was plenty that, yes, he did set the standard, but he also admitted that tolerance is possibly one of the factors. So there was, some evidence that came in that was helpful for the defense. Most of the evidence that came in through him was not very helpful, but there's other evidence that's come in that I think is very, very helpful and stands out for me as a defense attorney.
Lara, what do you think really this case is going to come down to here? Has the prosecution done enough to really show intent to kill that many patients?
I don't think they've done it at this point until now. And I think some of the cross-examination that we just watched is highly important because you could see even their witness is going to have to admit that the bedside doctor, the treating doctor who's there seeing the patient, who's got all the necessary information, is in the best position to make the decision as far as how much fentanyl and what to do for that particular patient. And I think it's an uphill battle. It's an uphill battle. And I haven't seen or heard anything yet that shows that he intended to kill all of these individuals, especially in light of some of the other evidence that I talked about earlier, including him having trying to resuscitate one of the patients that passed away, and some of the other information that we've seen.
Right, and there's also other patients where he gave massive amounts of fentanyl that didn't pass away, right, Lara? So, yeah, there's a lot still more to come in this case. It'll be fascinating to watch. Still with me, criminal defense attorney Lara Yeretsian. Lara, I want to get your opinion on this 88-page motion for a new trial by Smollett's attorneys. What do you think of the grounds that they weren't able to participate in jury selection process, that the judge didn't allow them the same amount of time to question a lot of the witnesses? What stands out to you as possibly some good grounds for a new trial?
Well, this was a high publicity case. I mean, you're talking about a client or a defendant who was already a celebrity before this case and became a bigger celebrity in a negative way, obviously, as a result of the case. And there was a lot of prejudgment. I agree with his counsel. There's a lot of prejudgment. So the least they should have had was the ability to ask all sorts of questions, to be able to weed out some of these jurors who are already biased, who could not be impartial. So they may have some good grounds there. We've seen that happen. We've seen cases overturned, as in the Scott Peterson case, where we had a situation of some misconduct by a juror who wasn't completely honest. So sometimes even asking 1,000,001 questions may not be able to bring out some of those biased jurors. So in a situation where they're not even allowed to ask enough questions, it's even worse. So there is a possibility that, maybe they've got good argument there. Now, also, as far as the witnesses are concerned and not being able to ask them questions, it all depends on the specific witness and what questions it is that they were going to ask them. If they were crucial witnesses and they go to the heart of the defense and the judge did not allow them, they may have some grounds there as well.
Right, and of course, this is a standard motion, right? Defense files motion for a new trial, alleging these grounds. He's also going to be sentenced to this Thursday. Again, guilty on 5 of those 6 counts of disorderly conduct, low-level felonies, Lara, maximum 3 years. What do you expect to happen in his sentencing on Thursday?
I would hope that he does not get any time. I mean, we have to remember, this is a case where he actually got diversion at some point. And if it wasn't for the high publicity, if it wasn't for the celebrity factor here, that probably would have stood. It happens every day in regular cases where people get diversionary type deals in cases as serious, if not more serious than this case. So the idea that that didn't stand and now he had to go through this entire ordeal and go through a trial and now potentially an appeal, I would think that a judge would see, what this case was all about, and at the end, maybe, hopefully, not give him any time, just place him on probation.
I'd be pretty mad about the waste of resources, though, that went into investigating this fake crime. But again, the city is suing him monetarily for those resources. Thank you, Lara. We're going to squeeze in a break.
I've been truthful and consistent on every single level since day one. I would not be my mother's son if I was capable of one drop of what I've been accused of. This has been an incredibly difficult time, honestly one of the worst of my entire life.
It is time for today's Talk Back segment. Each day we post a question. On Court TV social media pages, we gather your comments and questions and respond right here on the show. Well, the attorneys for Jussie Smollett, you just saw there, they filed a motion for a new trial. In early December, a Chicago jury found the Empire actor, Jussie Smollett, guilty of making up a brutal hate crime. So we asked our viewers, do you think he should get a new trial? Still with me, criminal defense attorney Lara Yeretsian. Lara, let's get to our first comment. It comes from Amanda Mobley. She says, the evidence is going to be the same. So why waste money on trying him again, Lara?
Basically, this is something that attorneys will file before, after a trial when the client is convicted. And usually what happens is they're denied, and a lot of times they're used as the basis for the appeal. So most likely this is not going to get granted, at least at the trial court level. It's going to be, obviously, it may be different at the appellate level, so we don't even have to worry about that at this point.
Right, and you're asking virtually the same judge who made a lot of these evidentiary decisions to overturn the original decision for a new trial. It's pretty tough. Just explain the likelihood that this will actually be granted.
Very slim to none.
Exactly. All right, let's get to our next comment. This one from Paulo. If there are legitimate grounds as to why he should be granted a new trial, sure, but new trials aren't granted just because. That is true, is it not, Lara?
Yes, I mean, new trials aren't granted just because, but if there are legitimate reasons, sometimes they are, but that's pretty rare. Again, I mean, these are just, this is a procedure that trial lawyers will use. They'll file it in the hopes that maybe they'll bring something to the judge's attention that would be a ground for a new trial. And most of the time, it's not granted. These aren't granted. And basically, they're used as the basis for the appeal. That's what it is.
Right. I mean, this one, 86 pages long. A lot of work went into this motion for a new trial, but it's not wasted time. Like you said, it is the basis for what they will use to appeal this conviction. Okay, let's get to our next comment from Regina James. She says, no, I believe he has caused enough damage. He needs to do his time and get it over with. Well, Lara, you said you sort of hope he doesn't get any time, maybe just some community service, which he doesn't have a criminal history here, and that may be something the judge lands on realistically.
I would hope so. And I mean, I'm sure the judge can also have him pay restitution as far as any damages, any losses. So that may be something that can be also handled within the criminal case. At least that's done in California. So we'll see. I don't expect him to do time, not with his lack of any priors. I just don't see it. Not in a case like this.
Yeah, we shall see. Maybe the judge will be in a good mood on Thursday. I'll be there, actually, in Chicago, just so you know. It's quite cold there. But here, let's go to our next comment. Let's fit another one. Kathy Norton says, absolutely not. Guilty, guilty, guilty. This trial really did bring a lot of strong opinions on both sides here, Lara. So, like you said, and I think the defense claimed this in the document, he was on trial in the media and convicted in the media before this even took place. They're citing that here, and I think we see that in a lot of comments, too.
I was about to say that. I think it's pretty clear from all the comments that you just read, not one was on his side. Not one is saying, this guy should get another trial. He's not guilty. He's innocent. It tells you how pervasive the prejudgment was in this case. And they may have a pretty decent argument as far as the publicity in this case, all the negative publicity. And again, I would hope that the judge sees the kind of case it is. I mean, eventually, at the end, he was the alleged victim. So mostly it's him who's being harmed, and some restitution.
Maybe the judge should use our comments in their motion. Thank you, Lara Yeretsian, for